Good morning, everyone. Lovely to see you here. My name's Kate Crawford. I'm based at Microsoft Research in New York, where I research the social impacts of machine learning. And I'm really excited to be chairing this session this morning on AI in the law. We're taking the law writ very broadly to address questions of justice, fairness, and due process. And I also want to note a really interesting theme that I've been seeing emerge in this conference. Particularly, we've already heard it echoed twice today by Anthony and by Adrian, and then yesterday by Shane Legg from DeepMind, that these near and medium-term concerns have very deep technical roots that I think will help us address the far more long-term existential questions that have also been a big part of this conference. So I'm delighted that this panel will be looking at some of those very real near and medium-term challenges, both from a legal and a technical perspective. We have a truly stellar panel for you today, so I'm going to quickly introduce you. To my far right, we have Ryan Calo from the University of Washington and the co-director of the Tech Policy Lab. We have Sam Altman, who is the president of Y Combinator and the co-founder of OpenAI. We have Matt Scherer, who you were introduced to earlier, who is an attorney and writes about AI. And here we have Kent Walker, who is a senior vice president and general counsel of Google. Please make them welcome. Now, you've already heard from both Matt and from Ryan at this conference, so what we're going to begin with is just very short opening statements from Sam and from Kent to set the scene before we begin our discussion. Kent, would you like to kick us off?
Sure. In just a couple of minutes, let me talk about law, regulation, principles, and problems. Law. The common law is a phenomenal thing. To build on Matt's earlier comments, we don't appreciate it because it's the ocean we swim in. But it's flexible, it's elastic, it's evolving, and it's one of the fundamental reasons why technology has evolved in the United States and England and Commonwealth countries in a way unprecedented in human history. It enables the input of evolving social consensus over time, and it focuses resources just when you want them to be focused, when the problems are starting to emerge and become clearer, because that's when you get the best answers. Contrast that to a civil law system, essentially the Napoleonic Code, which tends to search for the future-proof principle that can be written down for all time. That effort tends to underweight the importance of balancing potentially conflicting values and principles, and has been much less well adapted to dealing with social problems, particularly social problems created by fast-evolving technologies. So many of us grew up thinking of AI issues through the format of Asimov's laws. Asimov's laws are an example of Kantian principled decision-making, and they were fascinating, but they were useful in the context of his stories. They were great stories precisely because the laws failed. Right? Think about it. If the laws had worked in every case, you'd have nothing to write about. So when we look at self-driving cars, for example, and we get focused on the trolley car problem of killing the grandmother or the baby, I would hazard a guess that nobody in the room has ever, in their driving experience, ever faced the choice of which of these two people should I kill. And there's a real risk that if we fixate on that becomes an impediment to advancing technologies that will ultimately save the lives of 1.2 million people around the world every year. So that practical focus, I think, is very important, and to second Matt's comments about the common law as a great framework for being able to bring in industry consensus and ideas over time as necessary. Now, there was some talk yesterday about the need for more regulation, and even this morning the suggestion, should we have more regulation? The FAA was thrown out as a model. Realize there's a lot of regulation of AI already going on. Antitrust, privacy, defamation, concerns about discrimination are already regulated in Google's algorithms and Facebook's algorithms and many other algorithms that are already in practice around the world. It's just that regulation tends to look at effects and specific concerns that arise from those effects, which is actually a pretty grounded way to deal with those problems, because almost all of them have costs and benefits that need to be traded off, better accuracy versus concerns about discrimination or what have you. So be thoughtful about the notion of trying to regulate the basic research of AI. And that's what I hear when you hear, we need an FAA model. Think about what problem are you trying to solve and when are you trying to solve it? Remember the Wright brothers at Kitty Hawk flew their first plane in 1903. The federal government did not get into the business of regulating aviation until the 1930s. And the FAA was not created until 1958. There was an awful lot of time for the actual real-world problems to develop and for solutions to be crafted. I don't think most folks in the world want to have to submit their next research proposal to a federal government clearinghouse in the same way a pilot has to submit a flight plan to the FAA for clearance before you can take off. So thinking through the right time and the right structure and the right set of questions, I think is actually critical. Given all the focus on the importance of important problems that AI can solve, climate change, healthcare, you know the list. I'm delighted that the conference seems to have moved in a direction of focusing on these pragmatic problems. Max and I were joking about the importance of the boring stuff. Moonshots require a lot of boring calculation in the background. But that's a sign, I think, that we are really starting to wrestle with the in-the-weeds kinds of questions and move away from, no one wants to take an alarmist tone on this stuff. Because I do think there is a risk of, whether it's GMOs or nuclear power or stem cell research, that headlines don't tell the full story. And that this community is really engaging in a cross-company, cross-academic and company line in engaging in solutions to the problems that we've identified is a really great and hopeful sign. In that spirit, I think policymakers too, you've seen with the 4 different hearings that the White House has held, the UK has held hearings as well, as moving forward in a very solution-oriented way. Issues like we've talked a lot about employment transition, displacement and transition, and quality of life considerations, but also the discrimination question, which I think is mostly a subset of an accuracy and fairness determination. Inefficient discrimination, efficient discrimination, and the like. Liability and accountability will definitely be playing out in the context of driverless cars and a lot of other technologies in the next few years as these technologies start to hit the road. Transparency, we've talked about the desire for openness, but the concerns about both trade secrets and security risks. You really want to share with North Korea, with ISIS, et cetera, what constraints are appropriate or limitations on a principle of pure transparency, pure openness. All of these require case-specific, balanced trade-offs. And I think we're well down the path of that, and we have a lot of learnings from the regulation that's already out there. So I would propose that the ultimate principle that I'd be most comfortable with in the thinking of this is what I call the Spike Lee principle. Do the right thing. And I suspect that 90% of the conference would agree.
Thank you, Kent. Sam, your thoughts?
The other big short-term issue, I think, that is going to present a large legal and regulatory challenge is AI for cybersecurity. This is something where I think people are able to do incredible things today. We saw a demo that was using AI for generating great spear phishing emails and then generating voice, synthetic voice of the person for a phone call, a follow-up confirmation phone call. And that was the first hack I thought I would actually fall for in a long time. And there are many other things, which in the interest of time I won't go into, but I think the computer security landscape is going to really change this year because of AI. And we don't yet have our legal framework, our regulatory framework, certainly our technological framework has not yet caught up for this. So I think those are 2 important issues we can discuss more.
Thanks, Sam. But I want to actually take us back to the first day of the conference where Andrew Ng sort of listed out his big challenges for AI. And you might have noticed that one of the ones that he put right in the sort of top 3 was bias. And what we have seen over just the last 12 months, very serious investigations by ProPublica and others showing that there are already forms of substantial bias emerging from machine learning systems in criminal sentencing, in access to credit, in education, and also in employment. So these issues are already with us. So I'd like to begin with Ryan at the end and then ask the panel more broadly, what can we do to ensure, and you can think here if you will about legal implements, to ensure that AI doesn't entrench forms of disparate impact? What else can we do if it's more than just a question of accuracy, but actually more about the fact that these forms of bias are based in our large-scale training data sets? How do we address these problems, both legally and technically? Ryan.
Well, I think that's a great and really important question. I also want to amplify something you said at the beginning, which is that solving these problems now will help solve the problems that some in this room are worried about that are far down the line. In other words, getting traction on some of these questions like bias and getting expertise in government and having some governance structures will acclimate politicians and regulators to the to be in a position to eventually solve the kinds of problems that are midterm and ultimately, right? So, but to your specific question, look, I think that the first step we have to make is we have to ask about the context in which artificial intelligence is being deployed in the first place, and what are the social and economic factors in those. So I think part of the problem with, say, applying algorithms and machine learning to risk factors in criminal justice is that by and large people in criminal justice are subject to certain forces of which they have no control, are already looked down upon in society, have no real means by which to challenge the decisions that are made about them. So the first thing you have to ask yourself is, why is machine learning being applied here, and what is the socioeconomic and cultural context in which it's being applied? Once you make a decision to apply something in a particular context, right, once you've decided we're going to apply it here, then you have to ask a bunch of questions about how are we best positioned to combat the prospect of bias. Now that may be partly a product of making sure that the training sets are good. I mean, I heard an argument recently by an NYU researcher that there's ways in which the law might systematically bias training data sets, right, toward the retrograde. For example, copyright, right? So if you don't have copyright and you think that, I don't think you need copyright clearance in order to train a data set. I think that's not a proper interpretation of copyright law. But let's say you assume that you do, right?
And we're being sued on that theory now. Some people
yeah, exactly. But I mean, so like, let's say that you do, right? So let's say that you need, exactly. Maybe it's my Stanford Center for Internet and Society roots, but I just don't think that that's right. But let's assume that you decide, okay, well, I'm not going to risk it. I'm going to use a training data set that is in the public domain. Now remember, public domain, right? Death of the author plus a long time. Well, guess what? When that training set was created, there weren't any women doctors, right? So I mean, so there's ways that you can sort of think about the effects of the law and so forth. But then even after that, you might wonder, well, gosh, I mean, I'm suspicious. I'm worried that some harm is occurring here. How do I go about addressing that harm? Well, that gets to the recommendation that I said in the very beginning, and one that comes out of Kate and Meredith's workshop, and one that came out of the White House process in general, which is you need a means by which researchers feel empowered and comfortable testing that data. And if researchers feel like, gosh, if I reverse engineer this algorithm, or if I look too hard at this thing, then I'm going to get sued by the company under the Computer Fraud and Abuse Act, or the Digital Millennium Copyright Act, anti-circumvention, you might not get the research that discovers it, right? One last final thing I'll say about this, because I want to make sure to turn it over to our other panelists, is this is responsive in part to Kent's good point. I believe that we should do harm-based regulation. Like, at the end of the day, like, I get it, right? It's about harm. I understand that, right? But how do you know what the harm is? How do you even know that there's a harm occurring? The Federal Trade Commission, Maureen, the current FTC commissioners who on the GOP side and the likely candidates going forward, Josh Wright and so forth, they're going to emphasize harm-based intervention at the Federal Trade Commission. But the question becomes, how do you even know that that harm is occurring if it's occurring within a system on which you have no visibility whatsoever?
I want to throw a different question actually to Matt and to Kent, if I may, because as you know, our dear friend Alexa has recently been served with a subpoena so that she has to give up the secrets from someone's room, and this is something we're going to be seeing a lot more of, the idea of AI systems becoming confidential informants or snitches, if you will. You might have heard on yesterday's panel, one of the prognostications for AI is that we might be able to use AI systems to track people's pupil movements in order to really understand what they're thinking and feeling. That is a very intimate form of knowledge, and as Kent would know more than many people in this room, governments, and particularly authoritarian governments, are very interested in acquiring that information from technology companies. What are we going to do about things like the sort of data retention orders, national security letters, when AI has so much intimate information about us? How do we deal with it?
Let me answer that and then quickly come back to us. I'd also like to answer the other question. So this is an existing problem, and there are two fundamental solutions. One, we and most of the other tech companies are gathering large amounts of information, have been very public about our willingness to push back on governments that are over-gathering information. Most recently in the Alexa situation, there was somebody who had committed or alleged to have committed a murder. The police thought there might be something useful in his Alexa conversations. That's clearly not probable cause. When we get requests for, boy, I'd like every search done by everybody in Monterey because somebody did something bad in Pacific Grove, clearly overbroad dragnet sort of stuff. We push back on that all the time in a documented way that we make as public as we're permitted to, as do the other companies. Also, because many of the tech companies are US, the international system of multilateral assistance treaties, mutual legal assistance treaties, MLATs, requires other countries to come through US process to get information from us before we provide it out. Those two safeguards have actually been remarkably effective in avoiding dragnet surveillance and misuse. I take the point that we'll have more and more data to worry about, but the fundamental legal construct of distinguishing overbroad requests from narrow and tailored requests that we might feel good about. What was the bank robber doing on that particular moment when he was alleged to be robbing the bank or not? That might actually pass standards of probable cause, judicial warrants, Title III surveillance, and the like. And that's a nuanced question to figure out exactly how narrow it should be. But I'm relatively optimistic we'll get to an okay place. Let me come back to the discrimination question that was talked about a moment ago, because I think there are two categories of issue here. One is the accuracy question. Google famously misidentified somebody's friends as gorillas in our one of our dating bases in images.
African American friends specifically.
Yes. Obviously a bad training set mismatch. You can make the same mistake with spoons and forks as you can with people and gorillas, but you feel a lot worse about it when it's people and gorillas. So I think it's a call for the AI community to improve our accuracy, to improve our databases and our training sets. There are also mathematical errors that creep into the equation. So for example, when you do a survey in Google image search for the word physicist and look at images, overwhelmingly male. And that's because most physics websites, while they may have some women shown, have a majority of men shown. But if you take the most common representation from each of those many websites, they're all male. We need to do a better job of sampling to understand the richness of the underlying thing. That's the accuracy point. The second point is the intent point. Much of American law is focused on an intent not to discriminate, an intent not to collude. What does that mean in the context of artificial intelligence? There are some levels of discrimination. Let's say, Group X has a high debt-to-income ratio. Banks tend to use debt-to-income ratio in deciding whether to allow loans, deciding whether to grant credit cards. Should they be allowed to do that? If there's no intent to discriminate, but the effect is to discriminate, should you not be able to allow to take into account how much debt somebody has before giving them a loan? How much pressure, back pressure, should we put on that system? We already do it in some cases with regard to geographic discrimination, redlining. Should that be a general rule? Should we look at just effects and write intent out of the picture? Should the designers of the AI be presumed to have intent or not? And when you talk about different AIs potentially colluding, maybe you want to get to that separately.
Yeah.
That's a whole separate question of, you can, in many cases, get to a collusive outcome without any collusive intent through what in the law is called conscious parallelism. Completely legal today. Should it continue to be legal?
And thanks, Kent, because I think that's a really excellent survey of just how we've reached this point where there are some existing legal frameworks, but to some degree we're reaching some limits, some barriers in terms of how they can be interpreted with AI technologies. Matt, your thoughts on the use of AI, particularly as we move towards sort of more and more pervasive AI systems in relation to state surveillance?
Right. I'd actually like to tie together both that question and the bias question, and then also some of Anthony Romero's remarks from the previous panel. Let's see if I can weave all of that together. And the general point that I want to make is that the law is society's way of expressing what behavior is acceptable and what behavior is not. And for a lot of these very intimate issues, bias is one of them, and surveillance and privacy is another. There's kind of already an ever-changing societal equilibrium that the law has developed on how we want to manage these issues. So in discrimination, there's this tricky balance in most United States jurisdictions between, and Kent kind of touched on this, disparate impact and disparate treatment. But we also have, as part of that equilibrium, there are rules governing exactly how you can go about avoiding disparate impact and what constitutes disparate treatment. So I think that there's some question, and this is an example of what Anthony was talking about, of how the law can disrupt AI. Well, if you program a machine and your intent is to avoid a disparate impact by coming up with an algorithm that gives strong preference to people from underserved minority groups, there's a decent argument that you've been committing a different type of discrimination, disparate treatment discrimination. And so that's an issue. We developed that balance between disparate impact and disparate treatment over the course of several decades. And that's a hard, when you have that type of deeply embedded structure in the legal system, it's hard to unravel it. And the good and the bad news about privacy is that it's not, the equilibrium is not as well established. It's not anywhere close to as well established as it is, I think, for how we treat discrimination. And the consensus, I think, on what types of surveillance data companies should be allowed to keep and under what circumstances they turn them over to the government is going to be a matter that is going to be a source of public debate for, I'm sure, several years and decades.
Oh, indeed. And on the question of public debate, and knowing that we want to keep this relatively quick so we can get to our final panel, I'm going to open to questions from the floor now. I see we have one up the back here. Could someone please just run a mic in that direction, first there and then to Anthony.
The speed limit sign says 55 miles per hour. The cop pulls you over. You are going 63 miles per hour. You know the speed limit is fake. The cop knows the speed limit is fake. You're not quite sure whether the cop knows that you know that the cop knows that the speed limit is fake. And that's how our sort of massive game of pretend about the speed limit can still continue, with everyone pretending to keep a straight face about it. Our society is not ready for explicit, transparent cognition. Like, not just the law isn't ready, the society itself isn't ready to acknowledge, like, actual thought processes and what they say. No matter what you use to grant a loan, if it is explicit, if it is transparent, if it can be subpoenaed and examined by the courts that they understand exactly what thought process used to give the loan, you will be sued. Because the way we actually think about things and the way that we are supposed to think about things is divergent. We are not reflectively consistent, as we would say in decision theory.
Just checking, do you have a question that you'd like to make with that?
I genuinely don't know what we're going to do about the speed limit in robotic cars. We're not going to give up on robotic cars, and we're not going to stop pretending. What are we going to do?
Ryan, as a resident robot law professor, tell us what you would do with that problem.
I mean, look, at the end of the day, regulators have goals, and they understand to some degree, not enough, human nature. So in the state of Maryland, there are too many deer. And one way to cull deer is to give people hunting licenses, you know? And in theory, you could know the number of hunters, and you could know the number, of deer, and you could give enough hunting licenses so that we have as few deer and they're not running into the street. But what Maryland regulators know is that people cheat. But they know how much they cheat. They cheat by about 1 deer. So they set the number of licenses purposely below, knowing and even hoping that deer hunters will continue to cheat, right? In other words, I think that imagine in your particular, like whatever your particular area is, imagine you do machine learning, imagine, and people, sort of come to you and assume that there isn't a level of sophistication, that there isn't a, you know what I mean? It's just sort of, they have all these like, well, here's what you could do. You could just do this, you could use that. If you're an actor and people come and say, well, you just pretend to be people. And, and it's like, of course you're going to recoil at that and say, no. I mean, I have a lot of experience and there's a lot of method to this and so forth. It's the same thing with the law. I mean, we think about these things. And so what will we do about a driving limit Will we tear our hair out? I've torn a lot of my hair out already, but will we tear the rest of our hair out and say, no, of course, we will find a means by which to address that, right? So that's my very basic point. Now, what could we do specifically? Well, there's of course a range of options, right? I mean, we could just admit that it's not really 55 and we're going to reset it, and you know what I mean, and so forth. We could create a tolerable sort of range and so forth. I mean, there's lots of things we might be able to do, but I'm confident that questions like how fast should cars go will be resolvable. I really, really am, yeah.
We had a question here from Anthony. I'll keep the questions coming fast so that we can get lots of questions to our panel today, and then we have another one just over here.
I do think that the regulation possibilities are very close on the horizon. And I think, Ken, your analogy of like the Wright brothers flying in 19 whatever, and then the FAA coming in 1950, I think that type of hope is not going to bear out. And I think certainly when you look at, where it's already played out in terms of the iPhone encryption debate, the breaking open of the iPhone for the San Bernardino, I think the questions around this Amazon Echo debate in Arkansas, frankly, we ended up on the side of Amazon, saying that they shouldn't be forced to open up the debate. But we had a very lively debate within my organization. It's like, if a guy kills his wife, he will, the prosecutor should be able to get a search warrant to search the home. So why is Alexa all that different? So, I mean, we ended up with you, but it's not exactly a fait accompli that we will stay with you. And I think ultimately, this populism that has swept America, the minute you start executing these self-driving trucks that knock out all of Trump supporters in Michigan, Ohio, Pennsylvania, you're going to see such a plethora of state regulations banning self-driving trucks that your AI knickers are going to be in a twist. And so I really think, and then if I wanted to really then go be a little bit more alarmist, the conversation I overheard, and I'm with you, I'm a secular humanist, all into technology, a libertarian, get government off my back. If any one of the Republican governors that were fighting tooth and nail overheard the conversation yesterday about my frontal cortex connecting to a frontal cortex in the cloud, and that we're creating some superhuman evolutionary form of intelligence, if you don't think these Bible-thumping Republican governors are not going to enact regulations, they're going to try to shut down your labs, your industries, your research, come talk to me about abortion rights, come talk to me about evolution rights, right? Because that's what the battle we've been fighting.
Been through
All right,
yes.
so let me jump in on that. I want to be very clear on my point. The argument was not we should let 55 years go by until there's any regulation. To the contrary, my argument is that there's regulation now. It's not around the horizon, it's now. It started 5 years ago, right? But my point is that calls for general regulation of basic research until you've identified the particular problems you want to regulate, I think may be premature and get you in the wrong direction. In antitrust law, there are things like type 1 regulation, type 1 errors, type 2 errors. Too much regulation, you ban good mergers. Other direction. You can either ban good mergers or let bad mergers go through. You can also, I will call it type 3 mistakes. You can distort the regulatory framework in bad ways. And Britain, years ago, taxed cars based on how wide their cylinders were. So you got a generation of inefficiently long and narrow cylinders in British cars because the regulators applied the wrong measuring stick. Having some reasonable sense of what the harm is that you're trying to regulate, and then regulating is eminently sensible, and we should be doing that now, not in 55 years. We just shouldn't race to the answers before we pose the questions.
I'm going to leave last comments here from Ryan and from Sam.
Yeah, sorry, just quick. I mean, I just want to give you an accurate mental model of the state of regulation, right? I mean, I think that if we too loosely characterize Ken's comments, you might think that there are actually on the books regulations about artificial intelligence. There are no such regulations at all. What he's referring to is that there's a regulatory context that does, in some circumstances, provide redress for some kinds of harms, right? Whether we're all, right? I mean, I just want to make sure that that's the right.
Well, I would say, we're in the midst of regulatory proceedings right now with regard to the way Google search algorithm operates and a number of complaints on the antitrust context and privacy context, et cetera. I'm confident that Facebook and other companies face exactly the same kind of regulatory back and forth under existing laws, reviewing existing alleged harms and a balance back and forth of social benefit and social harm. So it's a real-world exercise. We haven't drafted them as AI regulation per se, but they are regulating the effects of AI just as much as they would otherwise.
I'm going to reframe this as one final comment from each panelist, and you get it's going to be a yes or no because our time is short. So allow me just to give you this. Do you think the law is ready to contend with the enormous shifts that are coming as AI is being implemented across everyday life incredibly rapidly right now and certainly in the medium term? Yes or no?
As a system, yes. Yes.
Never ask a lawyer a yes or no question.
Yes, I'm going to go with. I'm going to go with yes. I'm going to go with yes.
No.
Increasingly.
And on that excellent note, please thank our panelists for their excellent comments.
And thank you so much, Kate, for doing a fabulous job. That was great.